everybody. Happy Sunday. This is a special breaking live session. After yesterday, we did a live yesterday on Saturday about the new USCIS Memo, and I could not get to all of your questions. We had a lot more coming in, and so here we are again together. A lot of you guys have DM'd me your questions, so I'll get to your DM'd questions, and I'm obviously available here for your live questions as well. So that's what we're talking about today. We are talking about the USCIS memo that it has sent shockwaves throughout the community, the immigration law community, immigrants and family members. The media is all over it. Influencers are all over it. And in my opinion, it is being exaggerated. It is a big deal. It is going to have an impact on cases. It does not kill adjustment of status. It does not kill green cards as we know it, which is literally the language that some people have used. And I think that is dangerous and fear-mongering and attention-grabbing language. This is not what's happening. Okay, so we do know that Trump has Stephen Miller, who does not like immigration, does not like legal immigration, and they systematically are cutting ways that people legally immigrate. Top of the chopping block for them are people who were paroled in under the Biden administration. So like Venezuelans who were paroled in under Biden are, public enemy number one as far as the Trump administration is concerned. And we talked a little bit about the nuances of everything yesterday. I won't belabor it because there's a lot of law in this memo, and we could get into sort of the intricacies of, INA 245A and 245C and 245K, which we did yesterday. But the way that I would summarize all of that is that in 1996, Bill Clinton was the president, and an immigration reform bill was passed. There's this funny thing where sometimes Republican presidents manage to get through very positive immigration legislation, and Democratic presidents manage to get through harmful legislation. So amnesty was passed under Reagan, and IRA, the Illegal Immigration Reform and Immigrant Responsibility Act, was passed under Bill Clinton in 1996. And the IRA did a lot of stuff. It created bars to reentry for people who had unlawful presence. It created criminal bars. It really cracked down on drug crimes, etc. But what it also did was it created the structure for adjustment of status. And this is a law that passed through Congress that the president signed. And it very explicitly delineates adjustment of status. It defines it, and it talks about who's eligible and who's not eligible really, really clearly within the statute. And what that means is that an executive order or a memo or even a regulation cannot come in and alter clear congressional intent. That is not allowed. And so what I said on, posts and social media right when this first came out is this is super illegal. And it's not going to stand in the federal courts. And a lot of you guys, understandably and rightfully so, said what they do, everything else they do is illegal. So what's any different about this? And fair. First of all, fair. Second of all, what's different about this is that illegal abuses of people's constitutional rights or due process violations that are illegal, those are shouldn't be, but they are up for debate. They are up for nuance. People could view these things differently depending upon their political leanings. This is not that. This is INA 245C, who's eligible and ineligible and falls under an exception for an adjustment of status. And it's clear words right there in the statute. And the memo comes in and says something very different on the exact same topic than the statute says. And when you sue and you've got a clear stated difference between Congress, which passed a law, and the president, who wrote a memo, the courts are going to go with Congress. Okay, so that's why I feel confident about legislation. So what this is going to look like is this memo is going to impact cases, and we're going to talk about that today. There's going to be big litigation, so impact litigation, maybe a class action lawsuit where they're going to find a bunch of plaintiffs who are impacted by this stuff, and they're going to file a lawsuit, and they're going to say, these are examples of people who are impacted by a policy like this. And them and every other person like them, potential person like them, is part of a protected class. And we would like the court to protect this class and rule on this big question. So that litigation is definitely forthcoming. We don't know who's going to file it. There's a bunch of impact litigation shops like the ACLU, MALDEF. I don't know them specifically, but groups like them are all working out who's going to file the lawsuit. And probably there's going to be multiple lawsuits. Separately, individuals who are impacted by this can bring your own lawsuits. You can file a mandamus in federal court if your case is unnecessarily denied. And you can file a lawsuit if you're delayed. Mandamus is if your case is delayed. And then you can file a lawsuit if your case is denied. Well, if you're a lawyer and you're watching this and you're an immigration lawyer, you might say, hey, Kate, there's jurisdiction stripping in INA 245C or 245A that says you can't appeal or bring a denial of an adjustment into federal court. But you can if there are questions of law. So this precisely would be a question of law. So these cases even will be able to be litigated on an individual level in federal court. All that is to say is that this is not going to stand on a big picture level and on an individual case level. So let's get to what the memo says. This is a memo. The number is, did I write it down? 6020199 is the memo. And this is a memo that says adjustment of status is not a guaranteed right. It is a discretionary benefit. So where the statute says, if you are immediate relative of a U.S. citizen, even if you overstayed your visa, or if you're a VAWA applicant, or if you're an employment-based applicant and you have less than 180 days, you are eligible to adjust status. This memo says eligibility is not enough. This is an extraordinary benefit that is only going to be provided moving forward when there are positive discretionary factors, meaning this person really warrants a green card. The cases that are impacted by this, we don't precisely know right now. So anybody who tells you this kind of case, that kind of case, and not those other cases are the ones that are going to be impacted, they're lying. They don't know, because this memo was not clear. This memo does not give clear guidance, probably because they don't want to have it go to court. But it just sort of vaguely references an officer's discretion in these cases. What does that mean? Whenever they vaguely reference discretion, they send a big message out to adjudicators that says, decide this how you want. And then it's in the hands of the supervisors and the officers, and each office, the San Antonio field office, the Los Angeles field office, the Phoenix field office, they all have different supervisors, different people in charge, different officers, and they are all using their discretion and deciding things differently. So it's going to be messy and chaotic. And you're going to see posts that say, oh, my DACA advanced parole adjustment was approved in Houston. That doesn't mean all the other ones in Houston are going to be approved. It doesn't mean all the ones in San Antonio are going to be approved, etc. So we don't know. Nobody knows, including CIS officers. They're also like, what just happened? Nobody knows exactly how this is going to go. But what we do know is that the policy is illegal. It contradicts the law. It's going to be litigated, and that they're on some level going after people who entered on a visa or parole, who are applying through for a green card, probably through employment or marriage, and that those people now have to show they warrant an exercise of discretion. And so what I would recommend we all do is not freak out. We need to move forward, file our cases. It does apply to cases that have been filed already. That's a common question. Go ahead and file. And then one thing we can do now is start to prepare positive discretionary factors as part of our interview prep. Basically, good moral character. Tell the story of why you are a person who warrants a green card. So, do you have a job? Do you pay your taxes? Do you go to church? Do you volunteer? Do you have kids? Do you own a home? Do you run a business? Is your spouse sick? Are your parents sick? Are your in-laws sick? Do you help care for them? Like, what's the story of you and why you should get a green card and not have to leave the country? And obviously, for every single person, that story is different. And the way that you tell it and the evidence that you provide is different. Everybody who goes through this process now should have a lawyer, for sure. We can help you prepare your discretionary statement, make sure everything's followed to the letter of the law, respond to requests for evidence, respond to notice of intent to deny if they come, file motions to reconsider for denials, bring your case to federal court if we must. We can help you. And what I believe strongly is that, not that this is much ado about nothing. This is something, but I think this is a lot noisier than it will actually play out to be, because it's so illegal and it won't stand. And we are up in arms as a community, as a legal community, like, no, you don't. Oh, no, you do not. And we are all going to be fighting this for you. Us attorneys are going to be fighting this for you. Our impact litigators and our individual immigration lawyers like me and my colleagues who represent our clients are going to make sure that you guys who are eligible for your green cards under the law continue to get your green cards. So that's where I am. That's my position. And let's start getting to your questions. Is it already in effect? Yes. So this is a rare, immediately effective, in fact, retroactively effective policy, which is also kind of illegal, but maybe that's not something worth litigating, because it doesn't say this applies to all cases filed, on or after June 1st, 2026, which means it will apply to cases already filed. And we know that it does because we've had cases delayed. So after this memo came out, we had one of our attorneys in the office in San Antonio in an interview. And in the middle of that interview, someone came in and told the officer, we can't approve any cases right now. So that's why I say they're all sort of like scrambling. This was a surprise to them. And so now they're all recalibrating and figuring out how they're going to apply this. So it does apply, obviously, to cases that were already filed, cases that were pending, cases that are post-interview, and you're waiting for your mail decision. This is going to apply to you too. My boyfriend has a pending I-130 and he's under DACA, but he was brought here as a child and his mother overstayed the tourist visa. So I think that's a great discretionary case. I wonder who filed the I-130, because this is obviously not spousal if he's your boyfriend. So who's his petitioner? But in his case, if he's adjustment eligible, I'm going to recommend for him, you bring the positive discretion. Came as a child, mom made the decision to overstay. He's had DACA, which means he doesn't have a criminal history, graduated from high school. What does he do? Is he an electrician? You submit his electrical license, a letter of recommendation from his employer, a letter from you as his girlfriend about how great a guy he is. If he's a father, then you have an affidavit from the teachers with the kids' school records that say he's really involved. And then you have his last 3 tax returns, and you put together this package that shows that this is a guy who deserves to stay. And I hate having to recommend this because it's not required under the law, but I am a practical person, an attorney, and therefore I will help you guys, and everybody at my firm will too. We have 15 lawyers and we're all the same way. We are going to be practical. We are going to help you guys file what you need to file to get your cases approved. But if they don't approve the case, we also will go to battle for you and file motions and appeals and lawsuits when necessary. What about couples who did the interview already and are just waiting for the decision? You are included in this policy memo. I'm Venezuelan, and my decision has been on hold ever since all immigration processes were paused for Venezuelans. So you're going to be caught up in this. And you don't say in your question when you came here, but Venezuelans are definitely one of the targeted groups by this administration, particularly Venezuelans who came over in the 2021-2022 era. So if you were a Venezuelan who was paroled in, or you came in with a visa, during the Biden administration, I would expect to get an RFE or a NOID, a notice of intent to deny, and then prepare to respond to that. I was literally about to apply for the green card on Friday when the memo got released. Don't despair, still apply. This is what I mean. They want you to read some headline that says no more green cards and to not apply. That is not the case. They cannot do that. That is not legal. And by the time you, who applies now, get all the way to your green card interview, this is all going to be resolved through litigation. So it's almost like, you know how they say when you invest money into the stock market for your retirement and there's like ups and downs and dips and wars in Iran and all that stuff. And they're like, just don't look at your 401k because it's over time, it's going up. This is like that. You know, if you're just now filing your green card, I would just put blinders on and just file your application and just expect that this will resolve itself by then. Does this affect a 601 waiver that's being reviewed? Not technically. So a waiver is something you file for unlawful presence, fraud, criminal issues, etc. And so they don't say people who filed a waiver. This only applies to adjustment cases, and sometimes you have a waiver with an adjustment, but not regularly. But a waiver case is, we're essentially starting to file waiver cases with adjustment cases. I mean, not that you technically need a waiver, but when we do a waiver case, what we're filing is a bunch of positive discretion. So you're already submitting the information that I would recommend in a waiver case for your case. But have a lawyer do it. Have a lawyer that you trust do it. Make sure you guys are working with immigration lawyers who practice immigration law regularly, who have a good reputation, who have an active law license. Now is not the time to use a notario or a forms preparer. Please, just don't do it. I see too many cases and lives destroyed because people have tried to save a little bit of money on using someone who's not licensed. And now, especially with everything that's going on, doesn't have to be me or my firm. Just go to a lawyer that you trust. And there's a lot of good immigration lawyers. You submitted last night. Yay. Good. Awesome. Okay. If I married a U.S. citizen as a Canadian and was applying for a change of status, do you have to leave the country? No, you're eligible to adjust status as a Canadian. So and Canadians, it's interesting, you guys don't enter on tourist visas generally. You enter on, it's like a duration of status. It's like not a visa that's required. So one of the things they're going to be looking at is, did you have immigrant intent when you came in? Like, were you already married? Did you file for the green card right away? Did you actually know you were coming to move here when you said to the Border Patrol officer that you were coming as a visitor? So they'll look at when the marriage occurred, how long after you entered did you file, those kinds of things. So no, you should not have to leave the country. And I would like to consult with you directly to find out your level of risk in terms of this new memo and whether they're going to try and give you a hard time or not. How long will it take for the policy memo to be completely and permanently overturned? That's a great question. Also, what if it goes to the Supreme Court and they uphold it? So I would expect multiple lawsuits filed on this in various circuits. So there's federal courts in this country. There's like over 100. And then there's circuit courts of appeals. And the circuit courts all go up to the Supreme Court. And oftentimes there's what we call a circuit split, where like the Fifth Circuit, where I live in Texas, which is over Texas and Louisiana, is very conservative, anti-immigrant, will decide one thing. And then like the Fourth Circuit or the Second Circuit or some more lenient circuit will decide, or the Ninth Circuit, which is over California, they'll decide completely differently. And when we have a circuit split and two of these appellate circuit courts are different on the same issue, but it applies nationwide or it's precedential, that's when the Supreme Court will take up the issue. All of that takes a very, very, very long time. And this would be one that I would not expect the Supreme Court to take up because it, like I said, it's so clearly defined by Congress already. This isn't amorphous or ambiguous from a congressional perspective. So and that's a very long-winded answer to your question, which is how long is this going to take? Usually getting like a class certification or an injunction is going to be at least 3 to 6 months. So we're going to have to be fighting these cases on an individual basis by filing motions to reconsider or lawsuits, mandamus lawsuits in federal court, et cetera. So we're going to be having to get a little dirty, bloody, I should say, metaphorically, until we get a nationwide court order. This is the next question. I am so nervous. I've been married to my U.S. citizen husband since 2017. We have a 5-year-old daughter together. We lived in Australia, where I'm from, until 2024 when we visited here. And my husband decided to join the military because he was at risk of not making it due to his age. I've now overstayed my visa before applying for adjustment of status. I'm in true fear and panic. Don't panic. Your case is the one. You might as well lay out the fact pattern of what they aren't going to have trouble with. They don't mind people from Australia because there's racism in these decisions. They're not going to mind people from Australia. You came in 2024. Your husband's in the military. You have a kiddo. You've got the fact pattern to overcome issues. So just make sure you have a lawyer. You could get military parole in place, but you don't need it because you're in with the visa. Just make sure you have a lawyer and file, and don't worry. I'm not worried about you. I consulted with a couple of lawyers and basically was told to sit and wait for my I-130 to be approved. November court date for my wife facing removal. I'm a citizen. We have a U.S. citizen-born daughter. She had everything in black and white official government documents showing she was never out of status. We got a denial because my tax return didn't reflect my income. So I waited to file my 2020 return, which I did within 30 days. And before I could refile the 485, we got the notice. So to appear, there's no way they take my family away. We have court. So you can adjust status in court, and this memo doesn't apply to, or shouldn't apply to court cases. You do need that I-130 to be approved. I don't think you said where she comes from. If she's on one of the country ban lists, you can ask USCIS to fast track her I-130, but I wouldn't worry. I wouldn't worry about the ultimate outcome. She is at risk of detention. So you definitely want to have a lawyer, and you want to strategize before court, see if you can have a virtual hearing. There is an injunction in New York against courthouse detentions. I don't know if it applies to Buffalo. I think it was New York City was that injunction, but you want a lawyer before you go to court with her. But ultimately, they're not going to take her from you. I just wouldn't want her to be detained. Margot, hey, I'm a citizen and my husband is waiting on his green card. They gave him a 10-year work permit. Do you think he would have to go back to his country and wait for the decision? We have a son. They don't do 10-year work permits. So something's up with your fact pattern. Can you double check that? If they gave him just a 1-year work permit, then you guys should be fine. You might have to battle out this memo and have positive discretion, which a lawyer can help you do. Hi, Kate. I saw your post on Threads and your words gave me so much comfort. Good. I'm a Japanese citizen married to a United States citizen. We currently filed forms I-130 and I-45. Yesterday, our initial interview was officially scheduled for June 30th at the Queens field office in New York. However, because of the USCIS policy memo, I have been panicking about whether it applies to my case or if my upcoming interview will be canceled. When you have a chance, could you get back to me? No, they're not going to cancel your interview, but probably your case will be scrutinized under the new memo. So, sorry, I know the words are covering up my face. I'll sit on my foot for a second. So you are going to have your interview. You do want a lawyer. You're going to work on a positive discretionary packet. Again, discretion is, why do I deserve to stay here and get my green card as opposed to going back? And you don't have to do this under the law. So I am mad about it, but it's a good idea to go ahead and do it. And you're going to tell the story of why you shouldn't have to go back to Japan to get your green card. So who's here? Are they sick? Do you have a job? Are you a good person? Was there a reason of why you overstayed if you did, etc.? That's what you're going to put together, and you would want definitely you would want a lawyer to help you do this so you don't misstep or say something wrong or include evidence you shouldn't or not include evidence you should, etc. Okay, I self-petitioned for an I-140 through an EB national interest waiver, which was approved last year. Great job, April 4, 2025. My priority date became current March of this year. Immediately filed my I-45. Priority date was March 5th. Okay. I had my biometrics 2 weeks ago and woke up to the news that we F1 students have to return to our home countries to obtain a green card. No. That's not true. So let me just stop right now and say, look, listen to what this person said. This is somebody who's been watching headlines or listening to influencers. I woke up to the news that we F1 students have to return to our home countries to obtain a green card through consular processing. No, that is incorrect. That is scary language that has been said by people who don't understand this stuff in headlines. Reporters, influencers who are not lawyers, etc. This memo did not say you have to go home. This memo said in order for people to not have to go home, you have to show that you warrant a discretion. It's a bunch of blah, 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 blah. Okay? It basically like we want you to prove to us that you're worthy. That's the vibe, okay? And so first of all, that's not what the law says. Okay, so we're going to sue them, we, the collective we. Second of all, you're an F1 student who won a national interest waiver case. You're a badass, okay? You are someone that presumably, based on the limited information I have about you, is going to warrant a favorable exercise of discretion under this new memo. So please, what I really want everybody to do is do not take some limited headline and all of a sudden believe that you don't qualify anymore. You're going to have to go home. Everything's horrible. The green card system is broken, all that stuff. Like, don't catastrophize with this stupid memo. This stupid memo was written by somebody who doesn't understand the laws or how this whole thing is going to play out, honestly. So for you, my EB1 national interest waiver friend, just keep marching forward. You're going to be fine. Just have a good lawyer. It sounds like maybe you did some of this on your own already and you've done great. Now is the time that you invest in a lawyer. And I don't even do cases like yours. So this is not, self-interest. I'm not trying to get you to hire me. You need a lawyer at this point. That's my answer. Okay. I'm going to answer this one in English. Abogada, usted lleva mi caso con mi esposa. ¿Usted cree que me afecte con algo? Hola, Norberto. No tengo los detalles de tu caso en mi mente, eso no puedo contestar, pero mándeme un mensaje directo o mejor, debes comunicar directamente con tu equipo, con tu abogado, con tu paralegal, porque ellos están respondiendo a cada cliente que tiene esa pregunta y están disponibles para ustedes. Hello, I applied for a green card through my U.S. citizen spouse, and we had our interview this week. The I-130 was approved the next day. I had disclosed that I worked without authorization in the past. I came to the U.S. with an F1, and I'm still in lawful status. Right now, I'm waiting for approval of the 485. Will this decision affect my application? Yeah, maybe. If you disclose that you worked without authorization and you were on a valid F, that violates the terms of your F. And did you, for example, work without authorization and then leave the country or renew your F or get your F? And did you commit fraud or not disclose something that you've later disclosed? Those are the kinds of things that they're going to dig into. And you may have to respond and answer that. And we can help you do that. A lawyer can help you do that. I came in on a B2. I got married 4 months later, not planned. Good. That's good piece of information. I was out of status for 4 years before filing due to money issues and documents. I'm sick with worry that I'll be denied for overstay. Try not to worry. I totally understand. They do talk about overstays. This would be a case that we would help you work through, like how to tell the story of what happened and to argue that you warrant an exercise of discretion. How worried should my friend be if they just filed the I-130 waiting on it to process, haven't filed the other forms yet? Her husband overstayed and was detained and released on a, is there a second part to that question? Bond. So this sounds like this guy's in court and this memo doesn't or shouldn't apply to court cases. I've heard of one instance where a judge said this memo applied to them, which is stupid. It doesn't. But technically, legally, this memo is a USCIS policy memo and court is a different agency. And so it shouldn't apply in court cases. His problem is that he needs the I-130 to be adjudicated quickly, the family petition, which is not impacted by this memo. So there's going to be a rush potentially if the judge is like, I need a decision on this I-130, and then he'll be able to adjust status if he's eligible in court, and it shouldn't be impacted by the memo. Hi, this is Hamid, and I'm an immigrant who is working in the university on a J1 visa. I filed my EB1 since January 2024, but I haven't gotten anything. I have applied myself. My question is that is there anything I can do at this time? How can I be sure my case is safe and I'll get a response? Also, should I be concerned about my case because I hadn't any attorney? Thank you so much for your time and understanding. And again, this is one where I don't do your kind of case. So I'm not, I am going to suggest that you get an attorney now. I don't think it's harmed you necessarily that you haven't had one. I don't love that your case is still pending. To me, that feels like a long time if it's been close to 2 years. I also want to make sure, I want whatever attorney you hire to make sure that you don't have the 2-year foreign residency requirement on your J1. So every J1 is like a foreign exchange visa, and many of these have the requirement that you go back home for 2 years. And you can tell whether or not you have that requirement on your passport, on the sticker on your passport. But you should consult with a lawyer at this point and find out what's going on with your case for sure, and see if you can move it along. Hi, I came to the U.S. on January 8th, married my husband on April 28th, so that's more than 3 months, haven't overstayed, and I'm able to apply for a green card or no? I would say yes, go forth, apply. You waited 3 months. So yes, go ahead. Hi, I'm an F1 student from the UK, been here since 2022. I have been married to my husband since this year, and I was hoping to apply for adjustment. Great. I have my files ready, but I'm scared to apply. Do I need a lawyer or can I apply? I've been here legally, never been involved in anything illegal. Your advice would be helpful. I don't want to be separated with my husband for however long the process takes. Yeah, you are eligible for adjustment. File as soon as you can. We would do positive discretion for you. By the time you get to your interview, this will all be resolved. Everybody should have a lawyer for this process. Absolutely. Everybody should have a lawyer, especially now. The new director of USCIS is appointed by Trump, and he thinks he's law enforcement. So we've got to treat affirmative filings as if they are defensive. What does that mean? That means have a lawyer who knows what they're doing. I wanted to ask about the new USCIS policy memo regarding adjustment of status. I filed my I-45, I-65, and I-131 on March 20th, 2026, while maintaining my F1 OPT status based on my approved EB2 national interest waiver, I-140. My I-140 approval notice states that the petition indicates I'm in the United States and I will apply for adjustment of status, and mentions consular processing only as an alternative. Could you please let me know whether this new policy memo may affect my pending 485 and whether we need to take action? Technically, your 485 is included in this memo, but yours is a case that I think that they would approve under discretion, right? Because you came in on an F, you did not overstay, you got approved for your I-140. So I think that yours is a case that would be approved. But we're going to see this, going back to this. Nobody is able to say right now, these are the people who are going to be impacted and these ones aren't, because it's going to be different. First of all, the USCIS is recalibrating. They're all figuring out how to interpret and apply this memo. They all are going to use their own opinions and judgments, the supervisors in each field office and each individual officer. And we're going to see disparate decision-making all over the nation. And so until there's a nationwide lawsuit filed with like a class action or an injunction, it's going to be a hodgepodge of this and that. I'm sorry to say. Hi, is it okay if I ask a question about the memo? I have an immigration case in processing. I really don't know what all this means for me or what I should do now. What kind of case do you have? Tell me a little bit more. How do you see this affecting E2 to green card? We are in legal status. We came as a visitor, adjusted to E2 after purchasing a business. In 2025, my wife got a sponsor for the green card EB3 other workers category. The final action date is way down the road, and the date for filing will likely come up much sooner. We have maintained legal status the entire time. How do you think this will affect us? We are Canadian. So you're included, right? Like your case would be one that would be included under this memo, and you would be one that they would be looking at the positive, like they would be viewing from the positive lens. Like you came in as a tourist, yeah, but then you converted. Then you know, like you've maintained status this whole time. You might end up, I don't know if you're going to fall out of status based on your timeline, but just make sure you have a lawyer and you're doing everything as good as you can. And I think you're going to be fine. This is a Spanish question. Una duda, EB2. Ya nos aceptaron la I-140. Si tenemos H1B, H4, visa vigentes, ¿cómo quiere tendríamos que salir del país para el adjustment of status? ¿O solo aplica si las visas se vencen? Sí, aplica a todos, pero porque nunca se vencieron sus visas, probablemente no van a tener problemas ni demoras en tus casos. Hi, Kate. For F2A applicants, should we still try to AOS? Is going with the consular processing, what stage is it required to leave the state? So F2A are family members of permanent residents. You're not an immediate relative, and so you're not actually eligible for adjustment if you've overstayed. For F2A, in order to adjust, you have to have stayed in legal status since your entry, which is rare, unless you were in like an employment or student visa category. And if you were, then you're eligible to adjust. If you're not, then you have to consular process anyway. This post just handed me hope. Good. My husband and I are just a week or two out from being ready to file our applications. We have his medical appointment. We just need to upload everything and pay the fees. I was panicking. Yeah. Keep going, y'all. This is going to resolve. This will resolve. This is not going to stand. This is a bunch of bluster. You know what I mean? Like some Yahoo at USCIS got real high on their own supply and drafted some AI memo, and now everybody's panicking. And it doesn't mean cases aren't going to get impacted, but it ultimately is not going to fly. It's just not. It just contradicts the law, you know? And so it's just another iteration of them doing stupid stuff that they're going to get sued for, and the courts aren't going to allow. In some cases, the courts allow it, but like I said in the beginning of the video, like that stuff is more ambiguous or up to interpretation. I mean, you can argue with me on that point, and I see your point, and you're arguing silently with me. But Kate, due process isn't up for debate. Yes, I agree with you, and the courts have not found that way. But when we're talking about like statutory language and then a memo that says something exactly specifically different than that, the courts won't allow that. Okay, how is this legally different than the 75 country ban? Great. I mean, fair, totally fair question. And my sigh is not about your question. The country bans are, actually, the country bans are a really good example of what I'm talking about, because to you guys and to me, the country ban is illegal. It's race-based, country-specific immigration policy, which is not what we do historically. It's been disallowed. It's an equal rights violation, which, you know, violates constitutional protections. So how on earth have the courts allowed country bans in so many jurisdictions? Yes, agree. That's why I say country bans fall into that category of ambiguity that the courts are not clearly striking down, even though they should. Statutory language differences between a memo and a statute. I mean, judges, you know, they're going to look at that and be like, there's no way that we can allow this memo to stand because it directly contradicts the statute. In my opinion, this is all my opinion. What can we do if we're in the Fifth Circuit and they're sitting on a habeas? What district is your habeas filed in? Each judge decides these differently, and each district is different. What do we know about the pause for the 75 countries? Doing everything correctly and legally, but we were separated from our husbands and families and currently waiting with no help and no news at all. I'm so sorry. I am so sorry. The best thing you can do is have a good lawyer who can look at, whether we could file a mandamus for you, whether you could do congressional inquiry. Maybe, if you have a really compelling case, you could do a media campaign. There's things to be done in egregious cases, and you start with a lawyer that you trust. Hi, Kate. You got my case. I'm from Mexico, married my wife who is a citizen. What will this affect us? So this, I don't know. Are you doing a consular case or are you doing adjustment? If you're doing adjustment, this could potentially affect you. If you entered on a visa and, you're applying for the green card, I think we'll be able to get you approved. We just might have to put together a discretionary packet for you. My family applied for a green card petition, which is in review for almost 3 years. Is adjustment of status faster if I marry my girlfriend? Tell me the green card application that's pending for your family. Is this a U visa or a T visa? And you could file an adjustment even if you have a U visa or a T visa pending. Okay. LGBTQ, no impact, no separate impact. What about LGBTQ in this policy? They didn't mention, thank God, same-sex marriages in this memo. And there's no policy impacting same-sex marriages differently than what do you say? Do you say, if you're not referring to a same-sex marriage, do you say traditional marriage? Is that PC? What do you say? Somebody tell me who knows. Hello, ma'am. Hi, Marco. Should we still apply for I-130? Yes. Y'all, do not file. Do not file your case. File your case. Move forward. You're eligible. Go get it. My husband has been here since he is 14. He's waiting on a green card. We have a son. Does he have to go back? Is a warrant coming out for him? So this memo does not discuss like detention, warrants, etc. Separate thing. I don't know enough about your husband's case. Like, how did he enter? Have you filed for him? You say he's waiting on his green card. What did you file? When? I need a little bit more information. But no, people should not consular process if they're eligible to adjust status. Don't do that. Like, oh, for the love, please don't leave the country. Do not read this memo or some headline and be like, oh, I'm in a consular process now and book your flight. I have heard of people doing stuff like this over the years. And they're split from their families because they didn't consult with a lawyer before going. So for whatever you do, consult with a lawyer before you make a decision about leaving and consular processing, please. Me gustaría hablar con usted, por favor. Estoy en pláticas con su equipo. Puedes mandarme un mensaje directo con tu pregunta. Me and my fiance will be filing in December 2027. After she graduates, she's on a J1 student visa. Are we affected? Yeah, technically, you might want to consider, if she's on a valid J1, you might want to consider the timeline. So I would consult with a lawyer now as you're making decisions on like when to get married and when to file and all of that. Do you have any idea when the pause for 75 countries by the Department of State will be lifted? No, I'm sorry. I have heard of no moves to lift it. And the lawsuits challenging it are not all that going great. Any thoughts on current H-1B applying for a change of status? We're both Canadian. That to me seems like a very clean-cut, easy case. No reason not to file. How long do I have to wait to apply for a green card? My boyfriend and I have been together for 1 year and a half. He recently got his H-2B visa approved for the second time. Who's filing for a green card? Him? You're a citizen and you're filing for him. Get him in on the H-2B. Get him working on the H-2B for a little while, at least 90 days. Then I'm not telling you to intend to immigrate him. This is like, you cannot enter on a temporary visa like an H-2B with the intention to immigrate. If after he gets here on the H-2B and he's been working here for several months and you guys decide, hey, we like living together, we do want to get married and file for his green card, you can do that. That's not immigrant intent. But what you don't want to do is have him come in on the H-2B, knowing he's going to get married to you, file a green card, do all that quickly, never work at the H-2B job. That would look like fraud to them. Ooh, a lot of questions on the country pause. What about the pause on the 75 countries? We're doing everything correctly and legally, but we're currently we got this from you. Oh, you're Colombian. Let's do a consultation on your case. I'd like to see what's going on. But like I said, mandamus, congressional, media. It sucks that justice is being delivered based on geographic location. Totally. Yeah. I mean, there's a reason that we don't do it this way. I mean, the last time we had immigration policy based on where people were from was in 1924, maybe. I can't remember the exact year. It doesn't matter. The whole point was to create racist laws. And so we did a quota and we said, like, the proportion of people, we're going to give out all of our immigrant visas to people in the proportions that are already in the United States. So like 90% of the immigrant visas went to people from Western Europe. And Congress at the time really wanted to do something racist. And they for 2 years, they struggled with, how do we pass a racist law that the courts will uphold? It's like in the record. And they got it through, and the law went into effect. And because of that law, America got whiter and whiter and whiter meaning less diverse, over the next 40 years until the civil rights era, when we passed the laws that we currently have in place. And so ever since then, we haven't done country-specific racist laws, because it's like not who we have envisioned ourselves as a nation to be, until Trump became the president. And then he does stuff like cancels all refugees except for white Afrikaners who claim that they've been, persecuted because of their white race. The new immigration law saying that we have to go back to our country to fix. Is that true? See, this is what I mean. This is the message that I know you guys have received. And it's not a law. It's a memo. It says we're going to tell people to consular process unless they warrant discretion. It doesn't say people now have to go back to their country. So just be really cautious about allowing that message to seep in for you. Don't listen to media outlets, headlines, or influencers that freak you out and tell you things that are that simple and wrong. So if anybody says to you, if you read anything that says, oh, now the law is you have to go back to your country to get your green card. No, not true. And whoever is telling you that is not trustworthy. So stop following them. There's so much like, fear-mongering, misinformation online. And it's this kind of memo just fuels that fire. So you've got to be really discerning about who you follow and where you get your information. And this stuff is technical and it's nuanced, and it's not so entertaining to watch me live on a, 1 hour video talking about INA 245C. And this is real information coming from a real immigration lawyer, and it's the actual information for you. So just be really thoughtful about where you're getting your information. Okay. My wife is a Russian citizen. I'm a French citizen. We both have green cards. Mine expires in 2030, so I still have a few years, but I'm starting to think what I should do. We've been in the U.S. for 12 years. We own a home. Our life is here. We do not plan on retiring here. Do you expect I will run into issues when I renew my green card? First of all, no. One more detail. Many years ago, before my green card, my passport expired while my H-1B visa was valid, and my lawyers didn't realize that for 3 months. I had a new passport by then, but my visa stamp was on the old passport. I had to leave the U.S. and come back a week later to get a CBP stamp on the new one. I wonder if down the road they will reevaluate if my green card should not have been granted. Okay, no. So if you already have your green card, don't worry. This memo does not go back and review how you got your green card. They're not doing that. That is not what this contemplates. If you already have your green card, just find something else to worry about. There's plenty of other stuff. But in your case, you should become a citizen. You should apply for citizenship, not renew your green card. Why do I say this? You just told me you want to retire in another country. And if you retire in another country, you're going to lose your green card because you have to maintain your principal residence in the United States. So naturalize, get your citizenship, and then you can go wherever you want for as long as you want, and you can retire outside the country. Okay, my family applied a green card petition, which is a review for almost 3 years. That's too long. Is adjustment of status faster if I marry my girlfriend? I think you already posted that. I want to know what kind of case your family has. DM me. Let's do a consultation. Hi, Kate. I have a green card interview on June 15th. I'm a little concerned about the new policy that came into effect. Do you think this policy could negatively impact my interview or my pending case? So I'm assuming that this is a green card interview, in which case, yeah, this policy is applicable to you. And what you would want to do, you've got a few weeks, is prepare and bring positive discretionary evidence to your interview. This is something that your lawyer can help you do before your interview. Someone is legally in the United States on an H-1B visa, has a pending green card application. Would any of these reported changes affect their case? Technically, you're included, right, under the memo because you're applying for adjustment, but you are in the category of people that they discuss as someone who would warrant discretion. You haven't overstayed, you don't have fraud, valid H-1B, all of these factors I think should lead to you not having a whole lot of trouble, but to have a lawyer. Okay, hi Anna, we started the case. My last payment is coming up, but with all this going on, will this affect me? I don't know what kind of case we have for you, Anna. DM your legal team. I'm here on live. We're doing newsletters. Our lawyers are reaching out to all of our clients. So we're talking to you guys if you're impacted. Kate, wife is Brazilian, has a tourist visa. We got married in January, but she isn't coming until December of this year. We would have filed months ago, but am I still able to file the I-130 and the I-765 when she arrives? Okay, what you're talking about is considered fraud. So she already got married to you. She's out of the country. If she comes in intending to stay, she has immigrant intent and she's committing fraud. So you have a few options. You can file the I-130 and bring her here once that's approved. You could try to bring her here as a visitor without the intention to immigrate her, but she's married to you now, and so that could cause problems for her at the border or at the airport. I have seen people in her situation get detained and turned away, and it's really, really horrible and awful. So you might want to consider a consular case. Definitely you need to consult with a lawyer before you do anything. This is one of two-part question. I have an H-1B visa expired in 2020. I still have 4 years recapture time, currently hold a B2. I've been offered a job again by the same employer, will be entering the U.S. on a B2. Can I recapture my H-1B even if more than 6 years have elapsed? That's not a question I can answer on a live. That's a question for an employment immigration attorney, which I am not one. I can refer you to somebody that I trust if you DM me. I tried to renew my green card almost 1 year. I didn't receive it. What's the reason? That's a long time to not have your green card renewal. So send us a DM and we can look into. Let me just pause. I'm looking up the processing times. No, I'm not because my mouse isn't working. DM me and we'll see if we can do a case status inquiry for you. Hello, thank you for your support. I'm a professor at UT. Go. I have a work authorization approved until 2030. The university took care of me. I'm waiting for I-45 final approval. Great. Is there a second part to this question? I think that you're going to be fine if you're valid work permit. How do we consult? You can call my law firm. I cannot say my phone number on a live or else they will penalize me. So you can look me up, Kate Lincoln-Goldfinch, Lincoln-Goldfinch Law. We have free consultations, virtual. We have appointments available on Saturday. Ever since the election happened, we stopped charging for our consultations. So feel free to reach out. You can also DM me on any of the socials. Wherever you're watching me right now, you can just send a DM and say, I need a consultation, and my team will take care of you. Will this affect the visa ban countries, or will the resolution for this help that? No, this is separate and apart from the visa bans. Irrelevant, like they're running independently of each other. I came to the U.S. on January 8th, married my husband on April 20. Am I able to? I think we already answered this question. Yes, you can file for your green card. I came on an F1, completed my master's, then changed to an H1B. Great. Moved to EB2, EAD from H1B, currently pending AOS. No H1B. What level of risk? Very low. Very low level of risk. If you have more than 180 days of unlawful presence, maybe some issues. If you have less than 180 days, low risk. Does this memo apply to a child petitioning a parent? Yes. But again, the memo says something that the statute doesn't. And so even though the memo applies, the memo is illegal, it's going to get challenged in court. So it doesn't mean you shouldn't file. It just means you might have delays or complications. We filed an I-130 in September, interviewed in November. We still haven't gotten the decision. That's weird. He's Venezuelan. Shit. He was detained at his check-in. Is he still detained? Or did you get him out? If he's detained or Venezuelan, he's probably already in removal, in which case the memo doesn't apply. But I'm sure you know this. You guys need a lawyer. My wife and I are separated because she cannot get a visa for the USA presently due to the visa ban. How can we get her to the USA while we wait for our I-130 submitted September 2025? You can't. I'm sorry. VAWAs and more than a 2-year pending on 485 and 765. VAWAs are taking just under 2 years right now, Aldo. So you're not super wildly outside of processing times. Have a lawyer. This is a Spanish one. Mi novio tiene una visa H2B. Hemos estado juntos por 1 año y 5 meses. Yo soy ciudadana y esta es su segunda vez él viniendo. Debemos consultar porque él sí puede arreglar, pero él no debe entrar con esa visa intentando de aplicar para la residencia. Entonces, tiene que tomar la decisión después de la entrada. Hi, can you please guide if I'm trying to submit I-130 for my spouse, but it keeps giving me error for multiple eligibility options selected when I'm trying to upload the form? Don't do this by yourself. Get a lawyer. Yeah, just get a lawyer, because here's the deal. I see people submit the I-130 when they should do a one-step. And then, like, just the other day, I got an email from a guy who clearly educated, married a woman from Central America. I can't remember where. Wrote me because 2 years ago they got married and he filed, and then this happened, and then it got denied because they missed this deadline. And then now she's back in home country. And could you help me review this? And it was just like, makes my stomach twist when I read those emails, because it had this guy come to us when they met and fell in love. She'd already be a citizen, like, just use a lawyer, especially now. And an I-130, there's so many ways to just do it, just kind of sort of wrong. Like, if you are consular processing, but you select adjustment of status, the detected inactivity during your current live. Hold on. I have to drag a puzzle for TikTok to believe that I'm still here. Just give me a second. There we go. Okay. I'm still here, TikTok. Just calm down. Not y'all, but the app. I-130. If you say you are adjusting status, but you're actually consular processing, they send your approval to the lockbox, but they don't send it to the National Visa Center. And then if you just check that one little box wrong, you have to file a whole other form that has a whole other big filing fee and an 18-month wait. So it costs you more money. It delays your entire case by 18 months if you just get the little box wrong. Like, that's just an example of what can go wrong on an I-130. So it's just not worth it. And I know, like, I know y'all get sick of hearing me say it, and I know it sounds self-serving because I'm an immigration lawyer and I'm always like, hire a lawyer, hire a lawyer. It's because I see the consequences of not every day, and they're really gut-wrenching. That's why that's why I always say it. Okay. Hi, I'm on an H-1B. I applied for an EB-3. The I-45 receipt is May 5th. I-45, I-765 fees were withdrawn from my bank account May 22nd. Can I send positive discretion now? No. You're going to go, by the time you get to an interview, they're not going to need positive discretion. By the time you get to an interview, this will have been blocked by a court. So just wait. Don't stress. Vaguely pay attention to what's happening. Do not lose sleep over this. Make sure you have a good lawyer, and just trust that by the time you're getting ready for your interview, you're going to know what to do. You're going to be fine. I'm on an F1 status. I have an I-140 national NIW approved and an I-45 pending. Good. I have no overstay or unauthorized work. Great. My F1 visa will expire July 2027. How can this affect me? So you're one of these like golden children. So congratulations. They're going to love you. Don't stress. Before your interview, make sure you're prepared and you have a lawyer who knows what's going on with the policy and brings what you need. But you do not need to worry. I don't have a lawyer yet. My EAD is still pending. My marriage-based I-130, I-45 was scheduled for June 30th at the Queens, literally the day before. Oh, I see. It got scheduled the day before the policy memo. Is my case in danger? Do you think they will cancel my upcoming interview? No. You're fine. Just have a lawyer and just prepare. You're going to want some positive discretion to come to the interview. Okay. Gracias, Carla. I will do a video for you guys. My husband has Yemeni citizenship and his country is on the travel ban. Can he get deported to Yemen? What's his status in the U.S.? I need to know his status in the U.S. to answer that question. I-130 family applicants, B1 visa to green card, waiting 3 years, still under review. I-130 family applicants, but who's petitioning? Who's a petitioner? 3 years is too long. If you file an adjustment 3 years ago, or you filed an I-130 3 years ago, who petitioned whom and when? Does it affect VAWA? No. The statute says no. It says VAWA right there on the statute. So I hope they try. Let them try. My husband is from Turkey. He entered in 2022 on a B1, B2. We met in 2023, married 2025, and I have a 1-year-old daughter. Will a USC child and the fact that he financially supports us qualify as extraordinary circumstances? It will definitely count. This is definitely going to count toward his positive discretion. Like your story, basically, when he came on the B1, B2, what was he doing? Why did he come? Why did he stay? Why didn't he go back? How did you meet? Where's his family? What's going on with you? Are there health issues? Are there mental health issues? Does he pay taxes? All that stuff is going to be reviewed and considered under the new memo. I have a change of status case in processing, and right before the memo was a thing, they took the money for all my forms. I'm married to a U.S. citizen, and I don't know what I should do now. Do I just wait? Yeah, I mean, essentially, you just wait. They're not going to do anything if you've already filed. I would hire a lawyer. Like, you could come and hire me now. You've already filed your application, so basically, we will do You can hire us for interview prep. Now, I don't recommend this because in my experience, cases just are smoother and better when we do it from the beginning, right? So I'm not recommending that you guys file it and then come to us, because basically what we do is when somebody has filed something on their own or they hired an notario, we do a file review and then an interview prep. And so we'll review, ideally you have a copy of everything. We'll review it, see what we have to supplement, and then prep you review with you. So you could hire us now to do that for you if you want. Any thoughts on if this impacts adjustment of status for coming in on a K-1? It doesn't. It shouldn't under the memo doesn't specifically state it, but INA 245C exempts K-1 applicants, so it shouldn't. I'm on an O-1 visa and expires September 2027. I was wondering if I should start applying for my green card immediately. I'm worried. Yeah. Just generally, I mean, an O-1 is not a dual intent visa, so you're not supposed to apply for your green card immediately. But if you are eligible, it takes a while. So get it going because you only have until next September. So yeah. How about an F1 pending marriage with a U.S. citizen that's already been filed in April, and biometrics done on May? Will the pending case be sent back to home country to do an interview? So again, this is someone who got the wrong messaging. They're not sending cases back to home country to do an interview. They're saying you have to prove to us that you warrant an exercise of discretion rather than going home. So what this will look like for you is you'll get an interview, and then at the interview, you'll bring some positive discretion, and hopefully they'll approve you. Hopefully by the time you go to your interview, a lot of this will be resolved already by the courts. But again, you would be someone, if you didn't hire a lawyer to file, that you'd hire a lawyer now to review your application, supplement, prepare, and go to your interview with you. Hi, Kate. I'm currently working on a tenure track position at a public university. I have a valid H-1B. I've applied for a green card, got approval on EB-2 national interest waiver, later AB-1. My 485 is submitted. Great. I mean, I wouldn't worry. No, you're in the golden child territory. Where's your office? San Antonio or Austin? We're based in Austin. Do you know where the Fiesta supermarket is on 40th? We're like right on the other side of the highway from there, but we are mostly a virtual firm. So we do have in-office services, but we can represent people in San Antonio. We do, Zoom meetings. We're very, for a lot of our clients, virtual is better because you don't have to be out on the road. So you can come to us, or we can just do it all virtually. Friend has a person that was detained yesterday and is in California, Peruvian asylum. Could you take it? Maybe. It depends on where they're detained. But we can definitely consult. So DM me or have the family member DM me and we can help. My husband and I got married in December 2025. Okay, we started the applications for the marriage-based green card. He already had his medical, received his shots. We are currently working. Follow-up. Currently working a lawyer, final stages of filing. Great. Good. I mean, you're technically covered under this memo. Like, they're going to make you prove that until they get blocked by the court, you prove that you warrant positive discretion. But I imagine you will be able to do that, and your lawyer will help you with that, and you'll be fine. Prior self-removal, is it still possible to get residency to spouse? Maybe. So if you came and you left and you came back, if you had a year of unlawful presence, then you have a bar to reentry and you need a waiver, and it can get complicated. So you need a consultation. Hi, Kate. I filed marriage-based adjustment I-130 in early April. I'm Venezuelan, entered with a B-2 in 2020, had TPS until November, and had less than 180 days of overstay. Biometrics are done. With Venezuela in the country ban and the new adjustment memo, what should I expect for interview, EAD, and final approval? Do you have the EAD already? Go back to the previous question. We don't know if you have your EAD yet, but no, you don't if you just filed in April. The EAD should not be delayed, ideally. I don't know if they're going to give you trouble. They don't, they're going after Venezuelans, especially Venezuelans who came in under Biden. Now, you came in during the Trump era, right? And you had a visa, so maybe they'll process your case and at least give you an EAD. I don't know what they're going to do. You were going to have to watch and see. You should have a lawyer. If they delay it, you can file a mandamus. You can do a congressional inquiry, things like that. Oh, you missed your answer. Okay. Ms. Lamiano, thank you for responding. Is there a recording for me to check back? Thank you so much. Original question. Any thoughts on current H-1B applying for change of status? We are both Canadian. I think that is not, technically you're considered under the memo, but that's precisely what they're saying is like the category of people who don't have trouble. Like you're from Canada, you entered legally, you have an H-1B, which is a dual intent visa. So the H and the L allow you to have a visa and an intention to immigrate. Every other alphabet visa doesn't allow that. It's not, the U and the T maybe. But anyway, so if you Canadian, enter on an H, stayed in legal status the whole time, like that is literally the cookie cutter perfect case under this memo. Okay. Cecilia, hola, que yo tengo mi caso con ustedes, pero ya se venció este mes. El problema es que yo traté de renovarlo antes y sus ayudantes me dijeron que no podía. Ahora ya me dijeron mi trabajo que no enseño el nuevo, no puedo regresar al trabajo. Tengo permiso de la visa. Necesito revisar tu caso, Cecilia. Mándame un mensaje directo, por favor. First time watcher. Oh, you're kind and empathetic. Thank you so much for that feedback. I really appreciate that. Okay, John Farrell, catch 22. We interviewed in April, case being actively reviewed. Thailand is a banned country for applying, so leaving not an option. Just quick message, don't anybody leave based on this memo without talking to a lawyer first. We are married over a year. We have a lawyer and a co-sponsor. Overstay is her only issue. My immigration attorney, she isn't giving me a case number or tracking number. How can I track it? Almost 1 year hasn't come yet. Wait, did you say that you interviewed in April? You don't have a case number. You definitely have a case number if you already had an interview. But generally the ways to get your case number, guys, once you file, first of all, if you send something by mail to immigration, always send it with tracking. So either FedEx, UPS, or post office with certified mail, right? So you get tracking. Number one, always, always. Number two, if you pay with a credit card or a check, you can check the number of your case on your bank account. It'll have your case number. Number three, when you get a receipt notice, it'll also have your case number. And if you guys have been called to an interview, you definitely already have a case number. And I think you said you interviewed a year ago. That's a long time to wait. It's probably the country ban. You might just need to be renewing the work permit until the country ban issue is resolved. Pero si están esperando a la I-485, tienen que salir o solicitarla en su país. No, sí. Dicen que ciertas personas deben pedir su visa fuera de los Estados Unidos, pero mi recomendación es que nadie salga sin hablar con un abogado de inmigración, porque este memo no es legal y todos que están aplicando para el ajuste de estatus merecen ese ajuste bajo la ley y no deben tener que salir. My ex-husband has a green card through our marriage. We got divorced. 751 submitted, but it's in removal. He's not impacted by the memo. Can someone file 485 without a lawyer if their I-130 is approved? Technically, yes. Practically, I don't advise it. I've seen too many mishaps, especially now. Hace un año metí a la I-130, todavía no me la aprueben, pero no sé si mete el EOS. So I turned in the I-130. They haven't approved it. I don't know if I need to submit the adjustment. I mean, tenemos que consultar porque tengo muchas más preguntas. I need a consultation with you to ask my questions. I entered in January with a B2. I'm married in May. I have no crime, no overstay, good history in Brazil. I was a lawyer. I worked for the government. I have one daughter here. I apply. Yes, you can apply. You can definitely apply. for sure. This is a follow-up. What did you say before? It says he has a visa overstay and a pending TPS since 2024. Oh, husband. Okay, this is a question about your husband with Yemeni citizenship. He has a visa overstay, a pending TPS. He just applied for a green card. He had an M1. So he shouldn't be deported because of the country ban. The Yemen is on the banned list, so they're going to hold on his case. What I don't know is whether he's going to get his work permit. And he does, I think, run the risk of detention. So you guys should be really cautious about, travel and driving and all of that. Consult with me. You can DM me for a consultation and we can explore all of that. Dalita on Instagram. I have an L1A and right now on a perm process in the wage determination. Will this affect my process? I don't think so. So again, L is like the H. It's a dual intent visa, meaning you're allowed to have that in a file for a green card. And assuming all goes well with your perm and your L stays active, you're going to be fine. Follow up on the I-130 question. Entré legalmente, mi esposo es ciudadano. Okay, so sí, debe meter el ajuste de estatus ya. De hecho, deben hacer todo en un paquete normalmente. Thank you for F1 AOS marriage-based. May I ask what is positive proof contains? Okay, so basically we're talking about this discretionary question. And there isn't like a checklist of documents. It's essentially the story of you. So what they want to know, how'd you come? Why'd you stay? Why are you still here? Are you a good person? That's the net of what they're after. So you talk to your lawyer. You don't do this on your own because you don't want to accidentally sidestep, but you tell the story. Okay, so F1, I came here as a student. I studied. Maybe I couldn't go back because things got bad in my country or my family was dangerous or like there's a reason, right, that you stayed. And then you got married. So I met my husband in engineering school. I don't know what your story is. And we met and now we have 2 kids and these kids are, gifted and talented. And I, volunteer at church and we pay our taxes and like whatever. And his mom and dad are sick and I take them to the doctor every month, or like whatever the story of your family is, that's what you tell. Because you have to think about it like the officers have received this stupid memo that tells them they have all this discretion to decide whether people really value, warrant this discretionary benefit or not. And so they want to see in your packet that you are a worthy person. And it chaps because you are eligible legally. It is not a discretionary benefit in the way that they are describing it. And my recommendation is that we go ahead and start preparing the discretionary material. And then we also sue when they deny or delay cases unreasonably. Hi, Kate. Given the current admin, is any insight toward opting for K1 versus getting married on the ESTA? I'm a U.S. citizen. My partner is European. So is he here? Where is he? They're not going to love ESTA adjustments after this memo. So K1 is probably kind of where it's at. I need to consult with you guys. Like, where are you? Where's your fiance? Where are you? When do you want to be together? What's the priority? Is it being together? Is it doing it right? Not having trouble? Everybody's got different factors. So the best thing to do is have a confidential consultation with a lawyer. I mean, that's another thing about why you go to a lawyer and not some form preparer. Ethically, lawyers, everything you tell us is privileged. Unless you're planning to go murder somebody, whatever you tell us is private and nobody can get it out of us. Even if they subpoena us and take us to court, we still won't tell. So go to a lawyer and tell us the deal in a consultation and it's all protected. Prague. Okay. Yeah. I mean, ESTA entry and adjustment could be fraught under the new memo. I also can't advise it if that's the intent. Now, does he come on? If he comes on an ESTA and you guys are just like having fun and touring around the U.S. and you don't know what you're going to do, and then later decide you want to get married, technically that's allowed. Practically under this memo, it will probably be way more scrutinized than it has been in the past, as long as the memo stands. Do you that they would make a person leave immediately if denied in the interview or while waiting for approval or additional evidence requests? No. So denials are not going to happen probably in the interview. They're going to be by mail. And then in some cases, they're going to refer people to immigration court. And in immigration court, you have another chance to file for adjustment of status, and the memo doesn't apply in front of the judge. Some cases, they're not going to go to immigration court, and then you have to decide whether you're going to file a motion to reconsider the decision or bring a lawsuit. I'm an F1 student currently on OPT, married to an LPR. After I graduate and complete my F1, I'm on OPT right now. We were dating for 8 years prior to moving to the U.S. How to make our filing strong? It is strong. You're on F1. You're on OPT. Now, you're not eligible to adjust right away because your spouse is a permanent resident and the wait time is a couple of years. Have you filed the I-130 yet? If not, get that thing going. And you might want to consider, if you're married in Texas, an informal marriage, seeing that you've been together for 8 years. I don't know if you've already married formally, but in Texas, we have common law marriage, and you can select the date of inception of your marriage. And so if it needed to be last year, I mean, it wouldn't really matter for you, actually. That wouldn't bring you any benefit. So anyway, you need to file the I-130. Hi, I'm an F1 student, so my visa is valid until 2027 in July. So my girlfriend and I are dating since 2020. We do have evidence, so can we get married and adjust status? Yes, you can. Para clarificar lo anterior, estoy casado con un ciudadano americano. Mi ajuste de estatus es por matrimonio. Soy venezolano, entré con visa B2 en 2020, tuve TPS hasta noviembre, después quedé sin estatus con overstay de trabajo no autorizado. Todo fue declarado en la aplicación. Normalmente se perdona por ser spouse del ciudadano. Con el nuevo memo del ajuste y Venezuela en el country ban podría afectarnos en la entrevista. Sí, mi preocupación no es por el nuevo memo, pero por su país. Pienso que su caso va a tardar más tiempo, pero no sé si van a demorar la aprobación de su permiso de trabajo. Esa es mi pregunta. Hi, Kate. My I-485 has been submitted last November. How long should I still wait for the final result? EB1, now on H-1B. I don't know the answer to that question. Go to USCIS processing times, select I-485 form, and then the case type, and it'll tell you. I don't know this one off the top of my head, and my phone is on TikTok right now, so I can't do it for you. I have an upcoming interview with a pending case in 3 weeks with my wife. How will this memo affect me? So they may want positive discretion for her, explaining why she should get the green card through an adjustment. So you'd want to have a lawyer with you and prepare a discretionary application. Do we expect the BIA to rule on appeals in accordance with this memo? So this isn't a BIA thing because the BIA is over the immigration court system. So although they did cite some BIA cases, but what we expect is federal litigation and a federal court to stop this memo. That's my expectation. Okay, on the K1, does he have to be away for the entire time the visa is under review, and could I visit him? Yes, he does, and yes, you can. And again, the processing times, last time I checked on the K1 were between 6 and 9 months. I filed my I-485 based on an approved EB2 national interest waiver in March. My current F1 OPT expires in August. Good. Would you recommend applying for STEM OPT or changing to H-1B while my AOS is pending? Either, but it doesn't look to me. You haven't had an H-1B. So STEM is going to be easier probably. 8-year relation, married to an LPR. Oh, follow up. We married January 2026. We filed the F2A I-130 in February, AOS in April. Good, when the Chart B became current. We have a pending AOS, all completed, biometric now waiting. Great, all of that's great. You're in a good position. Nice summary, by the way. Succinct. Will this affect people who apply to adjust status through marriage? Yes. Ultimately, I mean, you'll have to prove discretion, then they'll get sued, then it'll stop. That's my crystal ball prediction. I applied to renew my green card a year ago. My lawyer said it would arrive by April, but it hasn't, nor did he provide with me a tracking or a case number. So he should. You can get a copy of your case file and a copy of your receipt notice. It's your legal right to have. And if he's not providing it with you, that's concerning. The fact that it's like May and he told you April is not as concerning to me as the fact that he hasn't given you tracking or a case number. My friend is an F1. She just married her fiance. Can she apply for a green card through marriage? Is he a U.S. citizen? Yes. If so, yes. Husband came, F1 came to the U.S. in 2022, graduated 2025, now working, no overstay. We married December 2025, filed April 2026, but we don't have any strong reason. Parent not here, no health issue, no kids yet. But it sounds like, did he stay? What did he do after graduation? Did he, how much unlawful presence time did he have? It looks like not much. I'm not that worried about y'all. I think that sounds fine and not problematic. Why are Venezuelan work authorizations being delayed? My friend has a pending case. His current asylum case is pending. His work permit is expired and it's still pending. It's the country ban. And this particular administration has it out for Venezuelans just in general. They're just after Venezuelans. And so you qualify for a work permit, but we are noticing delays. Does it apply to someone who has a 2-year green card and now has to apply to remove those conditions for the 10-year green card? Nope. You're exempted. Doesn't apply. This is someone giving me crap. This is totally illegal and won't happen. Has been said about 99% of what the U.S. administration has done in past. True. I agree. And this one is like on its face illegal, like in direct contradiction to the statute. It's less ambiguous than some of the other illegal stuff they've done that has been allowed. How long do court cases take for something like this? We have E2 visas. Our final action date for EW3 is severely backlogged, but dates for filing significantly quicker. This appears it will likely lengthen the timeline and potentially cause my wife to lose her sponsor. So you also reference court cases, but what you're talking about isn't a court case. So I don't think, the memo isn't related to your question and the court isn't related to your question. I think I need a little more clarity on your question. Después de que empiece el proceso para la green card de mi novio que tiene H2B, él tiene que seguir trabajando con su H2B visa o puede vivir conmigo después de nos casemos. Sí, tiene que seguir trabajando bajo el H2B por un rato, hasta que aplican para la residencia, para no tener fraude. If self-filing, do you think we should assemble positive discretionary evidence ourselves? We filed the I-130 for the spouse of a U.S. citizen, have an I-145 package ready and reviewed carefully. Okay, I don't recommend this. My recommendation is not to do this. For example, I would not have filed your case in two separate applications. I would have filed your I-130 and your 485 together to have it all processed together. Things get messy when you put it in separate packets. Not that you're going to be fine. Like, don't let me freak you out. But this is just one of those times when it's much better to just like have a lawyer file everything right from the beginning in the hands of a lawyer who can fix it if it goes awry. Lawyers allow payment plans. Like it's just worth the investment. But to your question about positive discretion, no, I would not do anything on positive discretion at the filing phase. Just wait till you get to the interview, because by then a lot of this will be a lot more clear. Okay. He's working now with OPT. His OPT expired in February 2027. We filed the 4565 I-130, I-131. He now has a pending AOS. So he's good. He's been in legal status the whole time. He's fine. You're fine. My husband is on H-1B and currently in the perm. Myself on H-4. Will we be affected by the latest memo? Probably not, as long as you stay in legal status the whole time. Does it apply for a marriage-based green card? Yes. I mean, according to the word of the memo, it does. According to the law, it should not. So we'll have to see how USCIS starts applying it. But the early behavior is that they are applying it to marriage-based cards. Okay, can you explain how this might affect someone whose case is processing or pending, already interviewed, waiting for an answer? They are retroactively applying this to cases already interviewed. And so they're going to go back and they're going to look and see, like, did this person overstay? Did they commit fraud? Are there any criminal issues? And when I say fraud, I mean, like, did they come in on a tourist visa and then immediately get married and apply for a green card? That kind of thing. Did they get parole? This is one thing that they're really mad about in the memo, is anybody who got 212D5 parole, which is how a lot of people came in under Biden or got out of detention under Biden. So they are going to be looking at pending cases. And basically what they might do is issue you a request for more evidence or a notice of intent to deny, which is harsher, obviously. Each of those gives you a window of time to respond. And it's in the letter that you get. Immediately, as soon as you get an answer, have a lawyer consult with a lawyer. We can usually get people in within 2 days. Do not wait until your RFE is like due the next week, because a lot of times we have to turn people away because we don't have capacity to respond quickly enough. So give us as much time as you get. Okay, I'm from Costa Rica. I'm married to a U.S. citizen. We got married about a year ago, lived the first 6 months in Costa Rica. In January, we decided to move to Florida because my wife has spent most of her life here. She had a good job opportunity. I arrived in early March. We were just about to send all our documentation to USCIS next week after 90 days of being here, including all the necessary forms with very strong evidence. But now I'm scared. I don't think you should be scared. I think you should move forward with filing, and you're going to, you'll have to discuss like the immigrant and when you get to your interview. But like that would be something we could help you do, or any good lawyer is going to help you prepare for your interview. Is there an approximate financial amount they look for as proof of financial support? How will I know if my partner make enough need to get? So that's actually specific. There's a form in the adjustment that you file that says how much the petitioner sponsor needs to make, and it's 125% of the poverty guidelines, which is about like $40,000 for a family of 4. That's real clear. Okay. Does this mean that in the future, anyone in the U.S. who submits an I-130 and 485 will be denied straight away? No. Or does it simply mean there will be a delay? Yes, in processing and getting interviews, during which time such a person will be able to get work authorization and have a protected status to prevent overstay. Yes. That's exactly right. It will delay cases. You'll have a work permit. You're not overstaying. It's not going to result in most cases, an outright denial. They're going to give you an opportunity to plead your case. Good morning. I'm scared for the memo. I'm a STEM OPT worker, passed EB2 national interest waiver last year. Could you please let me know how this impacts me? I'm currently on a TN, was recently selected in H-1B. Good for you. My employer filed a petition, change of status, effective October 1st. It was submitted with premium processing, so I expect a decision within 15 days. I have an event in Mexico on June 18th that I need to attend. Assuming the H-1B is approved. Is there more to that question? Would I still be able to travel to Mexico and re-enter the U.S. using my valid TN without issues, even with the approved H-1B in the background? This is a question for your employment immigration lawyer. Your company that's doing a TN and an H-1B will have hired an employment immigration lawyer. This is a question for them. There's too much nuance in your case for me to answer on this live. I'll be able to apply for my parents in December. They are here in the U.S. under F1 for the past 3.5 years. How will this affect us? I have enough income. They've never been out of status. Great. Do it. Go forth. I don't think you're going to have an issue. What about DACA for who did advanced parole? I heard of one that got approved in Houston since the memo. So, I mean, I think you'll be fine. You might have to come up with discretionary information. I think this might be a record for the longest live I've ever done. I'm sorry that this has so many people so scared. I really think that this is overblown and is not going to last in policy. I was just beginning to see what me and my husband had to do for him to apply for the green card. Should we wait? No, we live together in the U.S. I'm a U.S. citizen. Don't wait. Send me a DM. We'll do a consultation. How does it affect pending VAWA from last year? Had biometrics done. VAWA is exempted. The memo doesn't discuss VAWA, but the statute exempts VAWA. So no VAWA cases should be impacted. What do you think people should do who are both in the States? I'm a citizen. My fiance is waiting for his asylum interview. He lives here for 7 years already. We want to marry, apply for a green card. How will it possibly affect him? Should we still apply? Did he come in with a visa? How did he get here? Tell me that. I'm a student with a valid I-20, and my fiance and I are planning to get married and apply for adjustment of status after marriage. We have not been dating for long, just 2 months. Is it going to affect us? I mean, technically you're covered. Like you are, considered under the memo, but you're in valid student status, so you haven't overstayed. Presumably you haven't committed fraud. I think you'll be fine and won't have issues. Do you know if it is possible to get approved during the interview, or do you think they are still on hold since the memo? At least in San Antonio, they said they're not approving in the interview. And I imagine they're all going to get delayed now. They're not going to allow approvals on the spot anymore, I bet. How will this affect F1 OPT STEM to EB3 adjustment? I mean, you're technically included as an in-country adjustment, but if you've stayed in legal status the whole time, no fraud, no overstay, then you should be essentially exempted under the memo, unless you get some stupid officer who doesn't understand things, which is possible. Okay, you mentioned the new AOS memo doesn't apply in immigration court. Here in Portland, I heard this. Here in Portland, DHS used the same memo in court the same day as its release as grounds to oppose a court adjudication of a 485. It wasn't my case, but a local attorney let the rest of us know. I saw that too. So this memo is not controlling over judges, but clearly in some cases, DHS attorneys, which are the prosecutors in immigration court, are trying to use this memo. But any lawyer worth their salt is going to be like, first of all, not controlling. Second of all, it's an illegal memo and the judge better not issue a denial based on this memo or will appeal. I've already answered this question. A 601 waiver that's being reviewed. Technically, no, this is just an adjustment. So your 601 might be part of an adjustment packet. I'm so glad you're doing this. So many people and lawyers are speaking misinformation and you're factual, calm, and practical. Thank you. Thank you for that feedback. Yeah, that's why I'm here so long right now, because I can tell how freaked out people are. And by the questions that a lot of you guys are asking, I can tell that the message that's gone out is now people have to leave the country to get green cards. Like that's the simple distillation of a very complicated memo, and it's wrong. And my concern is that people are actually going to make decisions to leave or not file because they've, read some sort of simple headline. And that's not what you should do. You should move forward. You should file. You should have a lawyer, and you should fight. And this ultimately, I think, is not going to last, this memo. Hello, I applied for a green card through my U.S. citizen spouse. We had our interview this week. Great. The I-130 was approved the next day. I had disclosed that I had worked without, I already answered this one, I think. I came to the U.S. with an F1. We're good. Can you please explain a typical K-1 timeline, including applying for a green card or work visa process? Okay. So K-1 is the fiance visa. And this is how you get someone here before you've married. And like, this is, I think this might be the person who has a fiance who's in Prague. And so you would file a K-1. It's an I-129F that would take 6 or 9 months. And it basically, all you're proving is that you guys have met in person and you have a valid relationship and you have the intention to marry. Then your fiance gets invited, goes through the consular case and gets invited and comes here. And then you, once you get here, you file for the green card and you file for the adjustment, which wouldn't really be covered under this memo. What's difficult for fiancés, and this is part of the reason that there's even a show on this stuff, the 90-Day Fiancé, is that the fiancé gets, and then you can't work until you get the work permit. So you're stuck in this new country, in this new culture with your new partner with whom you presumably haven't lived together yet. And all of a sudden, it's just like everything's different. It's really hard on relationships. But you file for the green card and the work permit comes like 6 to 12 months after you file. And then your fiance can start working. So it's the proper way to get your fiance here and then apply for the green card. It is fraught with issues in that you have to wait to be together. Once they get here, they're not eligible to travel or work right away. And there's more costs associated because it's a multi-step process. So it's not ideal for a lot of people. Now, based on this new memo, coming in on a visa or an ESTA with the intention to adjust status could really be problematic and result in you getting denied. So it's worthy of a consultation to discuss all the ins and outs and potential consequences to make. It's a big decision. Does this affect someone that already has a green card and then green card is coming up for renewal? Nope. No. Does this apply to those who are legally married already? Yes. Yes. It applies to everybody who's applying for a green card. Will this impact the timelines for other AOS cases that are already in the queue? Yes. Yeah, everything's going to get delayed because of this memo. But presumably you have a work permit, you know, because you're supposed to get a work permit while your adjustment is pending. Okay. I saw the thread you posted about the new change of policy. Will this affect pending asylum applications? I don't think so. No. I mean, the memo isn't about asylum. It's unrelated. Okay. Let's do a couple more questions, like maybe 3 more questions, and then I'm sure this will be our topic du jour on Tuesday morning too. I have a pending H-1B transfer, and I've already resigned from the initial sponsor. Got married to a U.S. citizen, planning to apply for a green card through marriage. Should I do premium processing for H-1B? Yeah, probably. Yeah. Otherwise, they're going to take for a long time. Okay. I have an interview scheduled. Is it going to be okay, or may be going to cancel? No, they're not going to cancel your interview. They're going to have your interview. You just want to prepare for your interview and bring discretion, positive discretion. Okay. This is the last question. Are overstays automatically denied? No, there's no automatic anything. This is like discretionary, meaning every officer gets to basically do whatever they want, which means it's going to be chaos. Which means there aren't clear answers for everybody, but the best you can do is hire a lawyer, prepare a good application, prepare discretionary information, get ready to, fight, appeal, bring a lawsuit if you must. But at the end of the day, this is a very on its face illegal memo that's not going to stand. So we're going to have to respond while it's in place and handle it on an individual case level. Nobody should leave the country. Do not leave the country without talking to a lawyer. Don't delay filing. Consult with a lawyer. And don't let it freak you out too much, because I think that this is being blown out of proportion a little bit. Okay, last one. I have a tenant whose spouse has been deported. I found out that she's undocumented. They have 3 children that are U.S. citizens. Can I be held accountable for housing an undocumented person? No. Thank you for asking that question. No. Harboring somebody who's undocumented requires that you have knowledge about their status and an intention to hide them, meaning the police are knocking on your door and you lie and say that the person that they're looking for isn't home. Okay. So no, just renting your home to someone who might be undocumented is not harboring. Okay, one more question. I am in the process of applying for a marriage-based green card. I've never been out of status. There are no legal cases or issues against me. That sounds like a good one. That sounds like a good one. So go forth. Don't panic. Come back on Tuesday. I do a live show every Tuesday morning in English, every Thursday morning in Spanish at 9 a.m. Central. I'm here for you to answer your questions. So I'll see you guys on Tuesday morning. We can talk more about this. It's going to be okay. All right. See you guys soon. Bye.